Ready? Start. The court instructs you that the mere fact that the plaintiff received a fatal injury while working for the defendant does not entitle the plaintiff to recover a verdict in this case. The plaintiff is not entitled to recover a verdict unless she proves by a preponderance of the evidence, and by that is meant a greater weight of the evidence, the following propositions. Next para, first. The plaintiff must prove by a preponderance of the evidence that she was at the time and immediately before she received the injury in the exercise of reasonable and ordinary care for her own safety, and that she could not have prevented the injury to herself by the exercise of such reasonable and ordinary care. If she could have prevented said injury, then she was bound to do so, and if you find from the evidence that she failed to do so, and such failure contributed in any way to the happenings of the injury, the plaintiff is not entitled to recover in this suit. Next para, second. The plaintiff must also prove by the greater weight of the evidence that the top of the machine in question was in a dangerous and unsafe condition as charged in some one account of the declaration, and that the jury was caused by such dangerous and unsafe condition and was not caused by any want of ordinary care on the part of the plaintiff. Next para, third. The plaintiff must also prove by the greater weight of the evidence that Jones did not himself know of such unsafe and dangerous condition, and that he could not have known of it by the exercise of reasonable care. If you find from the evidence in this case that the plaintiff has failed to prove by the greater weight of the evidence all or any of the foregoing propositions contained in this instruction, which you have been instructed she is required to prove by the preponderance of the evidence, then you are instructed that she is not entitled to recover in this suit, and your verdict must be for the defendant.